Rule 45. Appeal by certiorari to the Supreme Court. Section 1. Filing of petition with Supreme Court. A party desiring to appeal by certiorari from a judgment, final order, or resolution of the Court of Appeals, the Sandigan Bayan, the Court of Tax Appeals, the Regional Trial Court, or other courts, whenever authorized by law, may file with the Supreme Court a verified petition for review on certiorari. The petition may include an application for a writ of preliminary injunction or other provisional remedies, and shall raise only questions of law which must be distinctly set forth. The petitioner may seek the same provisional remedies by verified motion, filed in the same action or proceeding at any time during its pendency. Section 2. Time for filing extension. The petition shall be filed within 15 days from notice of the judgment or final order or resolution appealed from, or of the denial of the petitioner's motion for new trial or reconsideration filed in due time after notice of the judgment. On motion duly filed and served, with full payment of the docket and other lawful fees, and the deposit for costs before the expiration of the reglementary period, the Supreme Court may, for justifiable reasons, grant an extension of 30 days only within which to file the petition. Section 3. Docket and other lawful fees, proof of service of petition. Unless he has theretofore done so, the petitioner shall pay the corresponding docket and other lawful fees to the Clerk of Court of the Supreme Court and deposit the amount of 500 pesos for costs at the time of the filing of the petition. Proof of service of a copy thereof on the lower court concerned and on the adverse party shall be submitted together with the petition. Section 4. Contents of petition. The petition shall be filed in 18 copies, with the original copy intended for the court being indicated as such by the petitioner, and shall state the full name of the appealing party as the petitioner and the adverse party as respondent, without impleading the lower courts or judges thereof either as petitioners or respondents. Indicate the material dates showing when notice of the judgment or final order or resolution subject thereof was received, when a motion for new trial or reconsideration, if any, was filed, and when notice of the denial thereof was received. Set forth concisely a statement of the matters involved and the reasons or arguments relied on for the allowance of the petition. Be accompanied by a clearly legible duplicate original or a certified true copy of the judgment or final order or resolution certified by the clerk of the court Akuo, and the requisite number of plain copies thereof, and such material portions of the record as would support the petition, and contain a sworn certification against forum shopping as provided in the last paragraph of Section 2, Rule 42. Section 5. Dismissal or denial of petition. The failure of the petitioner to comply with any of the foregoing requirements regarding the payment of the docket and other lawful fees, deposit for costs, proof of service of the petition, and the contents of and the documents which should accompany the petition shall be sufficient ground for the dismissal thereof. The Supreme Court may, on its own initiative, deny the petition on the ground that the appeal is without merit, or is prosecuted manifestly for delay, or that the questions raised therein are too unsubstantial to require consideration. Section 6. Review discretionary. A review is not a matter of right, but of sound judicial discretion, and will be granted only when there are special and important reasons therefor. The following, while neither controlling nor fully measuring the court's discretion, indicate the character of the reasons which will be considered. When the court Akuo has decided a question of substance, not theretofore determined by the Supreme Court, or has decided it in a way probably not in accord with law or with the applicable decisions of the Supreme Court. Or when the court a quo has so far departed from the accepted and usual course of judicial proceedings, or so far sanctioned such departure by a lower court as to call for an exercise of the power of supervision. Section 7. Pleadings and documents that may be required, sanctions. For purposes of determining whether the petition should be dismissed or denied pursuant to Section 5 of this rule, or where the petition is given due course under Section 8 hereof, the Supreme Court may require or allow the filing of such pleadings, briefs, memoranda, or documents as it may deem necessary within such periods and under such conditions as it may consider appropriate, and impose the corresponding sanctions in case of non-filing or unauthorized filing of such pleadings and documents, or non-compliance with the conditions therefore. Section 8. Due course, elevation of records. If the petition is given due course, the Supreme Court may require the elevation of the complete record of the case or specified parts thereof within 15 days from notice. Section 9. Rule applicable to both civil and criminal cases. The mode of appeal prescribed in this rule shall be applicable to both civil and criminal cases, except in criminal cases where the penalty imposed is death, reclusion perpetua, or life imprisonment.